closing your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Hold on just a second. It is annoying. Welcome to the show. I am your host, Daniel, and as always, it's a pleasure to be here today, even though it doesn't seem like it. Um, Spawn did a members only. I got a gifted membership to Spawn Troopers channel, and one of the, and I want to say this because I'm being brutally honest. I'm being brutally honest about this. I think it's something that needs to be said, and I'm going to put this to bed. But he said something about me being attacked and me being taken advantage because I have a mental disability, which is true. And the people who did it, the mental stress that I had gone through with what they did. They destroyed a channel that had almost the watch time hours. I was close. I was at 2,000 something watch time hours. I had all kinds of views on my channel, and they destroyed it. Deleting that channel and starting with this channel, I'm sorry. You don't know how stressful that is to me. You really don't know how stressful that is to me. And, every day I come on here, I feel the pain. Those wounds have healed, but the scars still hurt. Now, I'm going to come on here and I'm going to do the best that I can for you. That's why I chose to do court content, because I just got tired of the drama and I don't want to do the drama anymore. That's why I chose to do the court stuff and let the drama be in the courtrooms. But yes, it hurt me so bad what happened, and then having to start over again even hurt worse. And then they were still attacking this channel, even though I'm trying to move forward. What was I going to say? You know, I still don't know to this day. I'm going to try to come on here and bring this stuff to you. But the thing is, I don't know whether or not I'm going to be able to keep doing this because I want to walk away from it. I really seriously want to walk away from it. I'm going to try not to, but it hurts. What happened to me hurt, and it cut deep. Not only that, I lost friendship with a couple of people that I have a lot of respect for. I believe that one person was used as bait. I think they were used as bait. In other words, these people were using the platform for what they wanted. And when I tried to stop it, that's when they did their little attack thing. But today is Judge Mertz. I'm sorry to be talking so much. But that decision is something that I'll have to think about. That's something I'm going to have to think about. Do I want to keep doing this? Or do I want to walk away from it? But let's get on with Judge Mertz. So let me share screen. Let me make this bigger. Yes, I will be here watching. I'll be watching, but I'm going to have my microphone muted. But I'm going to be watching. So let's go to Judge George Mertz's courtroom. Let's see.
Phillips?
Yes, sir.
Okay, we'll go on the record in People versus Jody Phillips. This is file number 255438. The record should reflect Mr. Phillips is present today by video from Otsego County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church, on behalf of Mr. Phillips.
And Mr. Trush, can you tell me the status of this file today?
Yes, Your Honor. We're still working on trying to get a global resolution done with Otsego. Unfortunately, the last time we were here, I think we identified the same thing to Your Honor. However, Crawford was a little more efficient than Otsego. We still haven't got the case up in Otsego yet. We're set to have it up, I think, on the first week in November. So I would suggest to the court one more adjournment, I think, would be appropriate, and that's what I would ask for, so we can attempt to get that done there in the first week of November.
Okay, Ms. Coke.
I guess we could adjourn it again. We adjourned it on 9/5 for the same reason. I understand that the Otsego is not working as quickly, so I would not have an objection.
All right, I mean, that makes sense to me as a way to proceed if the case is just going to be bound over here in the next couple of weeks. So I'll set this for a plea hearing on the mid-November motion day, and we'll proceed at that time. Mr. Phillips, have you been able to hear everything we've been saying?
Yes, sir.
Do you have any objection to proceeding that way with your case here in this county?
No, sir, I do not.
Do you have any questions at all?
Not at this time. I've already spoke with my attorney, and he's already informed me of what was going to happen today, and I don't have any questions. Thank you.
Okay. All right. Thank you. We're going to go ahead and disconnect at this time.
Okay, thank you, sir.
Got a mystery person here, so I'm gonna try and see who this is.
We're all curious.
Hello, sir. Can you tell me your name, please?
Timothy Dwight Harris.
Mr. Harris.
On for 2:30.
Hold on one second, Mr. Harris. We're a little bit early on your case. It's set for 2:30.
Okay.
I'm gonna put you on hold here for a little bit. We'll try to take it early if we can.
He's the one from Arizona.
So I'm just gonna, oh, wait a second. You have another case you need to be in a different.
I'm up next in front of the court.
Okay. I've got Mr. Harris here. Do you have?
If I can grab that file.
Sure.
Probably.
Okay, Mr. Harris, your attorney's, he's kind of juggling court in two different courtrooms today, but I think he's gonna come in here, just momentarily, and I think we can take your case right now.
Okay.
Sarah's gonna let FOC know that we're doing this. Okay, so we'll go on the record in People versus Timothy Harris. And this, I'm just gonna mute you and rest common there. Sir, we got one case we need to take before yours, so I'm just gonna put you on mute for just a second.
Okay.
Okay, so again, this is People versus Harris, file number 255452. The record should reflect Mr. Harris is appearing today by video. If I could have both counsel put your turn.
Sierra Cook on behalf of the people.
And on behalf of Mr. Harris.
Vernon, I know you're just getting ready right now unexpectedly, but can you tell me what the status of this case is?
So last time we were here, we had a conversation about I had asked for some time because we wanted to address his criminal history that was aggravated drunk driving in Arizona. And so I pulled the statute and there are several different things that could register as an aggravated drunk driving. And several of them would not be felonies in the state of Michigan, so that'll be a sentencing issue. But I think I'm ready to proceed with the understanding that the agreement was that he would accept the plea and that he would be eligible for concurrent sentencing.
That's correct. The offer is plea to count 1, dismiss count 2 and all the habitual offender notices. And we would agree that it's concurrent based on when it happened. I think it's required to be concurrent.
Okay.
Mr. Harris,
Oh, I'm sorry. Go ahead.
sorry, Mr. Harris, is that your understanding of the agreement?
Yes, Your Honor.
And is that, so I have a plea sheet here that identifies those things. Is that something you want me to sign on your behalf?
Excuse me?
This is Adam, your attorney.
Okay, yes.
So is it okay if I sign that plea agreement that we just discussed?
Yes.
Okay.
Okay, so Mr. Harris, this is Judge Mertz again now. Did you want to go forward with that plea agreement today?
Yes.
Okay, can you raise your right hand, please?
Yes.
You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Harris, so under this plea agreement, you're going to plead guilty to count 1, which is delivering a counterfeit prescription form. That's in Michigan, that's a felony that carries with it a maximum possible penalty of up to 7 years and or a $5,000 fine. Do you understand that?
Yes, Your Honor.
And you understand that the parties agree that whatever sentence you would receive in this case, though, would run concurrent or at the same time as whatever sentence you're currently serving. Do you understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, the plea that you're making today, you don't have an automatic right to appeal that. You can only appeal by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
Right. Mr. Vernon, are you prepared to establish a factual basis?
I would ask the court to do it. I didn't prepare the questions beforehand, so I apologize.
All right, Mr. Harris, the allegation is that this occurred back on October 9th of 2021, so a number of years ago. Does that sound like the right time frame to you?
Yes, Your Honor.
Okay, and at that time, were you here in Crawford County in Michigan?
Yes, Your Honor.
All right, and did you try to obtain a controlled substance by using a prescription form that was counterfeit?
Yes, Your Honor.
And did you do that intentionally?
Yes, Your Honor.
Did you have any legal right to attempt to obtain a controlled substance in that way?
No, sir.
Ms. Koch, are you satisfied with the factual basis?
Yes.
Mr. Burns?
I am.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Vernon?
Only that I went over his guidelines with him. I explained to him that my scoring is not the court's scoring and that the court's not bound by that, but that, you know, those numbers may have influenced his opinion as to whether to accept the plea offer or not.
Okay. And Ms. Koch, are the people satisfied the court has complied with statute and court rule in taking this plea?
Yes.
Mr. Burns?
I am.
Mr. Harris, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Have you discussed in-person versus video sentencing?
I did not. I assume you would rather stay where he is,
And he's located where?
Arizona.
Arizona. Okay. So, Mr. Harris, you're located in the state of Arizona right now, is that correct?
Yes, Your Honor.
Okay. So you do have the right to have a sentencing hearing in person here in Crawford County in Michigan. And if you wanted to exercise that right, I would sign an order requiring you to be transported here for that purpose. You can waive that right and we can have that hearing by video as we're doing today. You know how you'd like to proceed in that regard?
Yeah, have it by video, Your Honor.
Okay. So we'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Someone from the probation department here in Michigan will be in touch with you to do a pre-sentence interview. There'll be a report prepared and you'll have a chance to speak with your lawyer about that report prior to the sentencing hearing. Do you have any questions about that?
No, sir, Your Honor.
Okay. Mr. Brennan, anything further?
Oh, yeah.
Let's go.
No, thank you, Your Honor.
All right, Mr. Harris, that's all for today. We're going to disconnect at this time.
Okay, thank you. Have a nice day.
Thank you. Do you know what
Okay, see you.
aggravating condition was?
I don't know, he's at least one impaired and one DWS, so it could be either of those two.
But
I don't know. There's a child.
There in Roscommon, sir, can you tell me your name, please?
Dan, Your Honor.
Okay, so we'll go on the record in Daniel Cyan. This is file number 255468. The record should reflect Diane is present today by video from Roscommon County.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trushing on behalf of Mr. Sine.
And Mr. Trush, can you tell me the status of this file today?
Well, Your Honor, Ms. Koch and I have been diligently negotiating on this. She made a slightly different offer than she had previously about a week or so ago. When I went over to the jail to discuss it with Mr. Cyan, though, he had bonded out. I did not know he was in Roscommon until I was alerted to that this morning, or actually this afternoon, rather. So under normal circumstances, I'd probably ask the court to consider putting me in a breakout room with Mr. Cyan. But I have the next probably 4 cases up and ready to go, so it doesn't seem like the most practical solution. I would indicate the offer that Ms. Koch has made is consistent with what I discussed with Mr. Cyan. I think he'd be inclined to take it, but again, I haven't had an opportunity to discuss it with him.
Okay. If we set this for a plea hearing on the full motion day in November, so in about 2 weeks, would you have that be able to proceed at that time?
I think that would be an appropriate way to proceed. Daniel, are you still going to be in Roscommon in 2 weeks?
Yes, sir, I am.
Okay. Ms. Koch, any objection?
No, but I will be revoking the plea offer at the next hearing.
Thank you. Mr. Cyan, do you have any questions about how we're going to proceed with your case?
Could I just ask, what the deal was that was made?
Mr. Trush.
Yeah, so it contemplates an added count 3 of delivery of a narcotic less than 50 grams as a habitual 4th offender, and count 2 possession of an analog. That would be a 2-year offense. And again, I'm going to come over and discuss with you the scoring of that as well as, what your options are.
Okay, so there hasn't been a plea as far as time made, an agreement as far as time?
No, but again, this does move this from the B grid to the D grid like we discussed.
Okay, understood.
Okay, thank you, Mr. Cyan. We're going to schedule you for another hearing in about 2 weeks. Again, in between now and then, you'll have an opportunity to speak with your lawyer, and we're going to go ahead and disconnect at this time.
Okay, thank you, Your Honor.
Ready on Ms. Harriman's case?
Yes, Your Honor.
Versus Harriman. This is file number 255417. Ms. Harriman, podium there. Second counsel.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Harriman.
How are we proceed today, Mr. Trush?
So, Your Honor, this is very much like the first case that we had up. We operated a little bit faster than Otsego. When we set this date, we were operating the assumption that Otsego's sentencing would occur before this, but it hasn't. Otsego's sentencing is going to be the first week of November. I have discussed with the prosecutor and provided her a copy of the PSI from Otsego County. The anticipation is if Ms. Harriman is given a jail sentence that exceeds 8 months, this charge is going to be dismissed. I think everybody expects that we're going to satisfy that in Otsego.
Let's go.
No objection to the adjournment.
Okay. So I will set this for another hearing in 30 days. We'll proceed at that time if it's not dismissed. I'm assuming between now and then, Ms. Koch would have a decision on that.
Yes.
Ms. Berman, do you have any questions?
No.
Thank you.
Here. No, these are yours. Okay.
Ma'am, can you unmute for me?
Yes.
Can you tell me what case you're signing in under?
I'm Heather Hatfield's case. I'm not sure what the name of it is.
People v. Glenn Price.
Yes, that is the case.
Which one?
People v. Glenn Price. I don't see it on the docket, but that's the case.
Yes.
So ma'am, apparently that case has been adjourned and we are not having a hearing in that case today.
Okay. Thank you.
All right, okay.
Bye-bye.
Mr. Kibbe, if you would come forward, please. We'll go on the record in People versus Elijah Kibbe. This is file number 255416. The record should reflect that Mr. Kibbe is present here in the courtroom today.
Sierra Coke on behalf of the people.
And Your Honor, Richard Shoestring will be acting Mr. Kibbe.
This is the date and time set for sentencing in this matter. Mr. Kibbe, have you had an adequate opportunity to go through the pre-sentence report with Mr. Church?
Yes, I have.
Okay. Mr. Church, so just so you and your client are aware, I did receive a letter from Teresa Romaniak. I believe that's your mom. Yeah, from mine. Did have a chance to review that letter, so I just want everyone to be aware of that. Mr. Church, are there any additions, deletions, or corrections to the report?
No, Your Honor.
This is the scoring of the guidelines.
No, Your
No,
Honor.
Your Honor.
Oh, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, the court's very familiar with Mr. Kibbe. You know, he's been in and out of our system for several years. We've done numerous jury trials with Mr. Kibbe. He's been to prison and out, and we're here again on the same type of charges. His guidelines are 10 to 23. His PRVs, they max out at 75. His are already at 120. After this today, they'll be at 145. His criminal record is absolutely terrible. You know, he has 8 misdemeanors and seven felonies, pending violations. I think we're probably looking at the high end of the guidelines as an appropriate sentence at this time. Thank you.
Mr. Church, anything about your client today?
Yes, thank you, Your Honor. I would suggest for the court, I mean, the prosecutor correctly identifies his prior history. He does have 7 prior felonies. The vast majority of those stem from one period of time, frankly, during COVID, when it was difficult to process cases. He was in active addiction then, and he's still struggling with that. That period of time, I think, accounts for 6 out of the 7 felony convictions that he has. And I don't say that to make an excuse, but it was a time where a lot of the systems that we rely on, a lot of the resources available to people struggling with addiction were shut down. They weren't active. As he presents to you here today, he served his MDOC sanction. He's released from MDOC after completing his programming there. And I think he'll be the first to tell you, you know, being back in the real world, right, back out in society, the application of some of those things he learned is a little bit different than it is in MDOC. It's a less structured, a less controlled environment. The circumstances here arrive, frankly, because when he was released, he allowed somebody into his life, into his circle, so to speak, that he shouldn't have. This is a person who had been kicked out of the MDOC housing, frankly, was living in a tent, and he took pity on them. They came to him essentially homeless, asking to be in his house. He knew he shouldn't have done it. He knew he wasn't supposed to do it. Frankly, he told Mike McFalda, hey, this person's here. They're not supposed to be. I don't want her here. Mike told him to call the police. That's not something Mr. Kibbe did, but probably something he should have done. Ultimately, that person brought drugs and led him down the road of a relapse. I would suggest to the court, I do think the recommendation here is appropriate. And I think it's appropriate through the lens of, we're talking about a small amount of drugs that were found. We're talking about a personal use amount. We're talking about a nonviolent offense. It would seem to me to go to the top end of the guidelines there is not appropriate. I think this type of offense should be on the lower end. And frankly, as weird as it is to say for someone with the amount of felonies he has, Mr. Kibbe is still fairly early in sort of his experience with the justice system. And again, I say that because he had this event a handful of years ago that resulted in all of these felonies, but that was really his first major interaction with the criminal justice system. I think that we are still in the position with Mr. Kibbe, albeit probably at the tail end of that, where we should be trying to focus on rehabilitation. We should be trying to focus on giving him the tools that he needs to be successful. I would suggest to the court the recommendation here, I think, is appropriate, and I would ask the court to consider allowing him at some point in the sentence to be able to utilize a treatment facility. And I would remind the court, again, he does not get credit for any of the time that he has been in the jail, but he's been in the jail for almost 7 months now. So again, while he's not necessarily entitled to credit for any of that, I would certainly suggest that there has already been a punishment element to it. Again, which I think is another reason why the lower end of the guidelines is appropriate.
All right, thank you, Mr. Kibbe. Anything you wanted to say?
I think Richard covered all. I just want to apologize to him, say I'm sorry to my family for my relapse, and look forward to moving forward with my recovery.
I did read through the report, so I'm familiar with the circumstances that bring you before the court here today. There's also a lot of information in that report about your own background, your history, and so forth. And I take all of that into consideration along with what the lawyers have had to say and what you've had to say. I did read your mom's letter. I know that, you know, she really wants to see you get better.
She's on my main support.
Yeah.
I would like to talk.
It came through loud and clear in that letter. And, you know, I'm sure as a parent, this is difficult for her to watch because she just wants the best for you. I have a lot of sympathy for her to read her letter. You know, in terms of what an appropriate sentence is here, I think everything Mr. Trush said makes a lot of sense if this is the first time you're coming before the court, and we didn't have all these other complicating factors here. You know, you've been on probation a number of times in the past. You've had a number of jail sentences in the past. You were on parole at the time that this occurred, so you know you knew the stakes are pretty high when you're on parole, and you just can't afford to mess up because the penalties get more severe after that. Your previous sentence was for 18 months in the Department of Corrections. On your last charge, you were on parole. From the standpoint of the justice system, where we look at progressive penalties, you know, the more that you continue to commit crimes, your level of punishment sentence doesn't get lighter; it usually goes up, and I think that's where we're at in this case. So, you know, again, if this was the first time, you didn't have the prior record that you had, there hadn't been prior efforts through probation to correct it that weren't successful. If you hadn't been on parole and continued to offend while on parole, I think there would be more confidence in the court looking at more of a rehabilitative sanction. But that's not what we're dealing with here. So looking at the situation as a whole, I think that a recommendation of Department of Correction time is appropriate as a progressive sanction. And it takes into account your parole status at the time this occurred. The court is going to sentence you to 23 months to 10 years in the Michigan Department of Corrections. You have credit for 0 days served again because of your parole status at the time. The court is going to impose a crime victim's assessment of $130, court costs of $325, $350, $68 state costs. You do have the ability to seek an appeal of the sentence. Mr. Trish, if you could provide Mr. Cody with appellate rights and let me know once he's acknowledged. Right here.
Yeah. Yeah. So let's go back to the court. That's me. So that goes, yeah.
Very many of the custody state this time for budget.
You're right.
Ready on Mr. Poirer's case.
Yes, Your Honor.
Bill versus Joseph Poirer, case number 255471. Ready to reflect Mr. Poirer's present here in the courtroom today. I get a counsel for your
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Shrewsbury on behalf of Mr. Poyer. This is the date and time set for a status conference. This is our first hearing up in circuit court. At present, we are working on getting some of the mental health records for Mr. Poyer available. So we're not at a position to resolve the case right now, although I would suggest a 30-day adjournment is probably appropriate for us to get the rest of the records we need to get, as well as potential diversion program or diversion plan from community mental health.
Ms. Cope.
Your Honor, we would ask that, this is our first hearing, that at the next hearing, we'll be revoking our plea offer, which was made on 9/17. This is a victim case, so if we don't get the case resolved at the next hearing, I'd ask to set it for trial.
Okay. You said 30 days, Mr. Church.
I think that would be sufficient. I mean, I'm already in contact with the providers.
Okay, so we'll set this for a plea hearing status conference in about 30 days. Mr. Poyer would be notified of the date and time of that hearing. It's important between now and then that you stay in touch with Mr. Church so that you're ready to proceed. If we don't have a plea at that hearing, the court will set this matter for trial. Do you have any questions about?
No, sir.
Okay. Thank you. That's all for today.
Mr. Poyer, what is the best address for the court to communicate with you at?
6429 Banner Trail, Grayling, Michigan.
The other one, sure, we'll do contact them.
Mr. Schlapp here.
Yes, he is.
Versus Zachary Schlapp, case number 255472. Record should reflect the defendant present here in the courtroom today.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Shrewsbury on behalf of Mr. Schlapp. This is the date and time set for a status conference. We do have an agreement for the court. That agreement contemplates a plea to count 1 with a dismissal of counts 2 and 3. Unwritten, but implicit in that agreement is that the prosecutor would not seek any enhancements. Do you think she could at least potentially apply a habitual offender notice?
That is a correct statement of the offer.
Mr. Schlapp, have you had a chance to speak to Mr. Church about this plea agreement?
Yes, I have, Your Honor.
And is that how you wanted to proceed today?
Yes, sir.
Raise your right hand. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth to help you God?
Yes, I do, Your Honor.
Mr. Schlapp, are you currently on any kind of probation or parole?
I'm on probation right now.
Okay, where's that?
Here with Alicia Morgan.
Okay, in the district court? Yeah. Do you know whether this is going to result in a violation?
No, it's not good.
You understand that the maximum possible penalty that you could face for fleeing and eluding fourth degree is up to 2 years and or a $2,000 fine.
Yes, I understand.
With that in mind, what is your plea to that charge today?
Guilty.
And now you have certain rights in the legal. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial, to not have that silence used against you, and the right to testify at a trial yourself if you want. Do you understand all of those rights?
Yes, I do, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, I do, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you'd have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal.
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said in your report today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are actually guilty?
Yes, I am.
This happened on August 20th of 2025. Is that the correct date?
Yes.
On that day, were you operating a vehicle here in Crawford County?
Yes, I was.
Did you come into contact with a police officer at some point? Yes. Okay. Did you know that that individual was a police officer?
I do. They turned on their lights and just, I don't know, just went from there.
Okay. So, officer tried to do a traffic stop. You knew based on the lights that you should have pulled over.
Yes, I did.
And you failed to do that. Yeah. Let's go for the people satisfied with the factual basis.
Yes, Your Honor.
Mr. Truitt.
I am satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on?
No, Your Honor.
No, I have none, Your Honor.
And are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
So if the court finds that your plea is knowing, voluntary, accurate, the court is satisfied that there is a factual basis to support a finding that you are guilty of this charge, the court will accept your guilty plea. Set this matter for sentencing hearing. You'll be notified of the date, time of that hearing. You're going to meet with one of the probation officers before you leave here today, Mr. McFelda, to set up a pre-sentence interview. Just make sure that you stay in touch with Mr. Truitt prior to that next hearing. Okay.
I understand.
Thank you.
Have a good day, Your Honor.
Mr. Thompson, were you ready with Ms. Danko's case?
I am. Thank you for waiting.
This is People versus Michelle Danko. And this is file number 255398. The record should reflect Ms. Danko's present here in the courtroom today. This is set as a probation violation hearing.
Yes, John, this is a probation violation hearing. The probation officer has advised that he would recommend 60 days in jail. If Ms. Danko was guilty, and I believe that's her intention.
Okay, Ms. Danko, have you had an opportunity to speak with Mr. Thompson about this?
Yeah.
Is that how you wanted to go forward today? Sorry.
Yes.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Danko, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yeah.
You understand that by pleading guilty to any of these alleged violations that you're going to be giving up that right?
Yes.
And you understand that the recommendation is for 60 days in jail?
Yes.
You understand that? Okay. Is there a particular count that she's going to plead to?
Judge, we discussed that she's gonna plead all 5 counts.
Okay.
And with the recommendation of the 60 days that actually was held in abeyance at her sentencing.
Oh.
And had continued on probation without prior terms.
Okay. All right. Ms. Danko, has anybody threatened you with anything to get you to plead guilty to these violations?
No.
Has anybody promised you anything other than what we've said here in court today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you did violate your probation?
Yes.
Okay, so let's talk about July 28th of 2025. At that time, were you on probation here in Crawford County? Were you aware that one of the conditions of your probation was that you were to not use or possess any controlled substances unless they were prescribed?
Yes.
And did you use the substance cocaine at that time?
Yes.
Did you use methamphetamine at that time?
Yes.
Okay. On August 13th of 2025, were you still on probation?
Yes.
Did you use cocaine on or about that day?
Yes.
On September 3rd of 2025, were you still on probation?
Yes.
And on or about that date, did you use cocaine and methamphetamine?
Yes.
All right. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. The court will accept your guilty plea. Are we going to proceed with sentencing today, or?
That would be our request, Your Honor.
Okay. Mr. McFell, did you have any objection to that?
No, Judge, that was the plan. And she does have 1 day jail credit, so 60 days with 1 day.
So Ms. Danko, have you had a chance to talk to Mr. Thompson about having the sentencing proceed today?
Yeah.
Okay. And is that your choice to proceed with that today as well?
Yeah.
Mr. McFell or Ms. Koch, anything on behalf of the people?
Your Honor, she has not done well. The court will recall at sentencing. The court gave her a speech, gave her no jail for this crime. I told her that, you know, if she got in trouble, she'd be going straight to jail and there'd be no hearing. And if she messed up, she wouldn't be passing go. She's not only messed up numerous times, but even since these happened, she is still testing positive as of this week when Mr. McFalda tested her just recently. I think that it is appropriate to give her the time that was held in abeyance, frankly, if not more. I'd ask the court to file the recommendation. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. I do understand the recommendation. I mean, I think the abeyance time is an appropriate sentence here. Ms. Danko wants to make sure the court understands, you know, this is not disrespectful to the court. This is a long-standing challenge for her. There have been times in her life where she's gotten, you know, clean and sober and done very well. It's always difficult when people are dealing with relapse. And, you know, I'm just hopeful this 60 days is a good opportunity for her to get herself back on her feet. You know, this is hurting her more than anybody. So she understands that she broke the rules of probation. And so the court takes all that. You know,
Mr. McFalda, do you have what the original guidelines were? States?
0 to 9 months, Your Honor.
0 to 9. Ms. Danko, anything you wanted to say? Okay. All right. Yeah, I think that's an appropriate recommendation. sounds like you're going through a rough time right now and you need to get some help for your substance use problem. And I'm gonna ask you when the 60 days is up to talk to Mr. McFelda. Part of probation is helping you find treatment if that's what you need. There's plenty of time in those guidelines. Rather see you out on probation working on this as opposed to sitting in jail. That's what's best for you going forward. And so try to get some help. Otherwise, we're just gonna be back here again. This, like Ms. Coke said, things haven't gone real well so far, okay?
Yeah.
So the court is going to impose the 60 days that were held in abeyance at the time of sentencing. The court is going to order that you continue on probation with all fines and costs remaining that have been unpaid.
Pretty much might be paid here.
Yeah.
Other than perhaps the supervision fee.
Okay, all right. Mr. McFelda, anything further on this file today?
No, Judge.
Mr. Thompson?
Nothing further, thank you.
Okay, so Ms. Danko, I'm going to go to court officer. Were you ready on this?
Yes, Judge, thank you.
It's People versus Peter Osorio. This is file number 255456. Early counsel is ready. I have counsel, both of you put your appearances on this.
Sierra Coke on behalf of the people.
Good afternoon, Judge. I just spotted on behalf of Mr. Peter Osorio, who's present standing to my right. Judge, thank you so much for taking us a favor.
Yes, thank you. This is the date and time set for sentencing. Mr. Osorio, did you have an adequate opportunity to go through that pre-sentence report and talk to Ms. Fodich about that? Yes.
Thank you, Judge, for pronouncing. I think you're the first judge that pronounced my name correctly.
Well, Sarah, give me a heads
Well,
up.
thank you, Sarah. I
I
appreciate
remember from our last hearing, so.
it just took me, it kind of shocked me for a bit that somebody said it, so I appreciate it, Judge.
I can take credit for it.
Well, thank you, Sarah. Judge, I did go over the PSI report in detail with my client. There is just a couple of minor things that I wanted to correct, and also I did have one thing that needed to be corrected with respect to the sentencing guidelines.
Okay.
So would you like me to start with the sentencing guidelines first, or just with the minor?
Yeah.
Okay, so I don't know if this is necessary or not, but on the first page, it states that he began using alcohol in 1983, and then there's a slash. He stopped, obviously, on the date of the offense. May 23rd of 2025 was the last time that he consumed alcohol. Wasn't sure whether or not that was necessary to be put in that section, Judge, but he has not consumed any alcohol while on bond, so he's definitely taken this very seriously.
Hold on 1 second. We'll just take them one at a time. Ms.
Yeah,
Pope, do you have any objection to changing that to 1983 to the date of offense?
No.
We'll make that correction.
Thank you, Judge. Again, I don't know, again, if I'm just being a little bit picky, I don't think, obviously, this doesn't affect the PSI at all, but if we go look on page 7 of the pre-sentence investigation, where his family members are listed with their ages and addresses, and the occupation is all left blank. Again, this doesn't affect the PSI, but I do want the court to know that my client does have a very, very close-knit family. Siblings who are highly educated with professions ranging from mechanics to accountants to RNs and also doctors. His sister is in the courtroom, Judge, for support. Again, it was just left blank. This is not some of the new information that I received from my client. Again, not sure whether or not that's really necessary, but I just wanted to state that on the record.
I'm not going to have that added to it. I certainly will take note of that.
Thank you, Judge.
Preserve the record.
Thank you, Judge. Now, as far as the sentencing guidelines, the OVs are scored correctly, Judge. If we look at the PRVs, PRV 5 is scored 2, as if one prior misdemeanor conviction should be counted, Judge. But if we look at his prior record, the last conviction that he has was the last DUI in 2011. He was discharged from that case in 2012. So that does not satisfy the 10-year gap rule, Judge, because the new offense occurred in 2023. So we're outside of the 10 years. So I believe the PRV 5 should be 0, which would lower the sentencing guidelines from 0 to 9 to 0 to 6.
Mr. Haven or Ms.
Your Honor, it does appear that the count in the middle of that 10-year gap was dismissed, so I would agree that it probably should be scored at 0.
So, issue with that?
No.
Okay.
Thank you, Judge.
All right,
Nothing
so
else.
just tell me again, so if we score PRP 5 at 0, that's 0, we move down to A, and what are the guidelines?
0 to 9. I'm sorry, 0 to 6 instead of 0 to 9.
Oh. All right, any other challenges?
No, Judge.
So, people have any additional solutions or corrections?
No, Your Honor.
Any challenges to this scoring?
No.
People for allegations.
Your Honor, I think the recommendation is appropriate. The court is aware of all the facts in the PSI. Generally, we see a much higher recommendation on the OWI third, but there is a large gap since his last one, and his BAC was relatively low. I guess compared to what we sometimes see here in this court. So I just ask the court to follow the recommendation. Thank you.
Anything on behalf of your
Yes, Judge, just very briefly, my client is 58 years old. He is gainfully employed. He's always worked as a mechanic pretty much his entire life. He currently works for Master Tech Auto Works. He, as stated on the record, Judge, has a very, very supportive family. His sister is here in court with him. There has been no violations that I'm aware of while on bond. The last DUI did occur in 2011, Judge, so there was that large gap of approximately 14 years with no criminal convictions in between. My client does acknowledge that he's an alcoholic. From day one, he has acknowledged that to me, Judge, that he's an alcoholic, that there's definitely some issues. His father was an alcoholic. It appears that his grandfather was an alcoholic as well. So my client understands what that means, and he understands that he has to take this seriously. And hopefully, Judge, this was his rock bottom, and he never finds himself in the same situation again. As far as the recommendation, Judge, I do believe that it is actually very reasonable. The BAC, again, was very low. It was 0.11, 0.10 on the road. Again, there was that big gap for approximately 14 years between the last DUI offense and then this offense. I do have an acceptance letter that my client was accepted into the sobriety court program in Waterford District Court, which is the 51st District Court. I could provide that to Mr. Haven, Judge. I'm not sure whether or not the Madam Prosecutor has that, Judge, but I do have an additional copy if she'd like to review that, Judge. So obviously, as this court is aware, the 30 days is mandatory on a felony DUI, Judge. However, if my client enters a sobriety court program, you have the discretion to waive that, and I'm hoping that you do suspend the 30 days, Judge. I believe the sobriety court program is going to be great for my client. I know that this court is very aware the sobriety court program is a very, very strict program. There cannot be any hiccups. If there are, he is going to be going to jail. But from what I hear, from my experience with clients entering the sobriety court program, they seem to do quite well, Judge, if they do take it seriously. I do believe my client takes this seriously. I do believe that he will do extremely well in sobriety court. So I'm respectfully requesting that you allow him to enter the sobriety court program in the 51st District Court, that you waive the 30 days and allow him to enter immediately, Judge. Just because I've had some clients enter sobriety court, there's going to be some documents that I'll have to make sure that everybody signs, Judge, and I'll promise to get that over to you if you allow that, Judge. Thank you.
Okay. Mr. Osorio, anything you wanted to say today?
Yes, I am an alcoholic. And so by me entering the sobriety court, I know that they'll definitely put this, behind me, because at my age, I can't continue living my life, with alcohol. It's just taking taking me down. So I definitely don't want to go out like that. So.
I did read through the report, so I'm familiar with what happened in this particular case. There's also a lot of information in that report about you, your background, and your circumstances.
Yes.
I take all of that into consideration, along with what the lawyers had to say and yourself. And obviously, you had a big gap in your contacts with the criminal justice system. That doesn't mean that you weren't using alcohol at that
Right. No,
time,
I was using
but you
alcohol,
weren't
yes.
endangering yourself or anybody else. And I think what your attorney said is important for you to recognize, and I think that you do, and I hope that you do going forward, and that is that this is just not something that you can use. There are people that can casually drink it, that just can't. And maybe one of those people that just can't. And you've had enough contacts now where you know that.
Yes.
And so there shouldn't be any doubt in your mind that this is something that you get involved with. to continue to monitor, to continue to follow through with treatment programs and things like that, even after you're off probation. Because going forward, you never say to another judge or court that, hey, I didn't really know that this was this bad. Because now we all know that. And so it's something that you're going to have to continue to follow through with for the rest of your life. Avoid being back here because, as Ms. Coe said, this time now you're looking at 4. You're looking at the potential of long jail time and prison time. And your stage in life, that's not something you want to do. So I hope that you do successfully complete the sobriety court program. I hope that you successfully complete this probation and move forward.
I will, Your Honor.
Good, and I look forward to signing a successful discharge. If you don't, then you need to understand the consequences of that, and those consequences will likely involve spending time in jail.
I can assure you that we'll complete this program and I'll be cured and you will never see me again.
Okay.
Not here or State Mission or anywhere.
Good. Well, I hope that's the way that it goes. So the court is going to follow the recommendation. The court is going to place you on probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The most important one is going to be your participation in and successful completion of that sobriety course program.
Okay.
The court is going to sentence you by statute to 30 days in the Crawford County Jail with credit for 2 days served. I will hold that time in advance. If you successfully complete the sobriety court program, and that's something the court can waive later fully. I usually hold that in advance in case there are problems. But if you do successfully complete that program, it's time to never happens. The court is going to impose a $130 crime victims assessment, court costs of $325, fine of $500, a reimbursement fee for the OUIL testing of $150, testing fee of $60, $68 state cost, along with any fines or costs that are required as a condition of participation in the sobriety court program. The court is going to impose a supervision fee of $30 per month while you're on probation. I would consider waiving that supervision fee again if you're under the jurisdiction of the sobriety court program and you're just on some kind of phone recording or something like that. I don't think we need to have two separate supervision fees.
And I'll look into that, Judge, as well.
Can I pay those fines today?
Yes.
Yes, we all want the money up front.
Okay.
Judge, did you assess the fine?
Yes.
Okay, great.
Okay, you do have the ability to seek an appeal of this sentence. Ms. Fudge, on that table there are Mr. Azario's appellate rights. Oh, did you?
I already got it. Your clerk just gave that to me. Your assistant gave that to me, Judge. So I do want the record to reflect that I'm handing the notice of right to appellate review and request for appointment of attorney to my client. He did sign the receipt of notice. I believe your honor, you should have a copy. I believe one goes to the prosecutor and then 2 to, okay, perfect.
Just I took his bond money, so the total balance was 680.
Okay.
Yes.
So thank you. That's all. Good luck to you going.
Thank you, Judge. Nice to meet you. Thank you.
Like 3:15, 3:30.
You can have them file over, or you can go by Zoom. Thank you.
All right, so got everybody connected. So let's go on the record in People versus Dooley. This is file number 255458. Both Mr. Dooley and his counsel are present by Zoom video by prior approval of the court. Counsel, can you just put your appearance on for the record for me, please?
Yes, Your Honor. Jared Shuey, P number 75877 on behalf of Mr. Dooley.
Sierra Cook on behalf of the people.
All right, Mr. Shuey, how do we want to proceed with your client's case today?
Yes, Your Honor. I apologize to Ms. Coach. I was going to send her that form that she sent us, but we are accepting the offer of pleading to count 1, fleeing and eluding 4th degree, and the added count 7, operating while intoxicated, upon successful plea and sentencing, that the remainder would be dismissed, is my understanding.
Is that a first OUIL?
Yes, first OWI.
Okay, for OWI. Okay, other than that, Ms. Cope, is that a correct statement of the plea offer?
It is.
Okay. Mr. Dooley, were you able to hear that? I'm gonna need you to, oh yeah, you're unmuted. Okay, Mr. Dooley, were you able to hear what your counsel stated?
Yes, Your Honor.
You had an adequate opportunity to discuss that plea agreement with your attorney?
Yes, I did.
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Dooley, are you currently on any kind of probation or parole?
No.
All right, and you understand that by pleading guilty to count 1, which is 4th degree fleeing and eluding, that carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine?
Yes, I understand.
And then by pleading guilty to a first offense, operating while intoxicated, that's a misdemeanor that carries with it a maximum penalty of up to 93 days in jail. Do you understand that?
Yes, Your Honor.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, I understand.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. And that means that you would have to ask for the Court of Appeals in Michigan to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are actually guilty of these charges?
Yes.
So the information I have indicates this happened back on August 7th of 2025. Is that the correct date?
That is correct.
And on that day, have you been consuming some alcohol?
On that date, yes.
Okay. And after you consumed alcohol, did you operate a vehicle on I-75 here in Crawford County?
I did.
And did you have any blood or breath tests done to determine the level of alcohol in your system?
Yes, I did.
Was that level above a 0.08?
It was.
Do you have any reason to doubt the accuracy of those tests?
I do not.
Had you consumed enough alcohol that you believe your blood alcohol level was above the legal limit here in Michigan?
Yes, I had.
All right. During the course of that interaction, did the police try to get you to stop your vehicle?
They did.
Did they do that by turning on their lights or sirens or giving you some other indication that they wanted you to pull over?
Lights.
Okay. Did you know that that's what they wanted you to do?
I did.
You failed to do that.
That is correct.
Okay. Ms. Koch, are you satisfied with the factual basis?
Yes.
Mr. Shuey, are you satisfied with the factual basis?
I am, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, thank you.
Mr. Shuey, are you?
I am not, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes.
Mr. Shuey, are you?
Yes, Your Honor.
Mr. Dooley, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from the probation department is going to be in touch with you to do a pre-sentence investigation. It's part of the order of the court that you comply with and cooperate with that pre-sentence investigation. Do you understand that?
Yes, Your Honor.
Also, that sentencing hearing will be in person here in Crawford County, so you and counsel will need to make arrangements to travel here for that hearing and be present here personally in the courtroom, okay?
Okay, understood.
Mr. Shuey, anything else from your side today?
Nothing further, Your Honor.
Mr. McCullough, do you have contact information?
No, Judge, he could provide his phone number.
Mr. Dooley, can you give us your phone number so that the probation department can contact you?
Yes, the phone number is 207-266-9993.
Thank you. Ms. Koch, anything further from your side?
No.
All right. Mr. Dooley, did you have any questions at all?
I don't have any questions, but I will be going back to work, and I work night shifts. So I may not answer the call right away, but I will make sure to call back.
Okay. All right. Thank you. Mr. Shuey, anything further from your side?
Nothing further, Your Honor.
All right. Thank you. All parties are free to disconnect on this case.
Thank you.
Thank you.
Okay, we've got everybody connected. We'll go on the record and People versus Daniel Knight. This is file number 255433. Both Mr. Knight and Mr. Hunt are present today by video by prior approval of the court. Mr. Hunt, can you just put your appearance on for the record, please?
Yeah, Jim Hunt, representing Dan Knight.
Thank you. Ms. Koch?
It's my understanding that defense wants to enter a plea, and I defer to defense counsel to put the plea on the record if that's what he wishes to do today.
All right. Mr. Hunt, how does your client want to proceed?
Your Honor, there's been an offer made that if my client pleads guilty to an OWI third, that the other two charges would be dismissed. I discussed with the prosecutor my client's lack of recall of what occurred that day, and I asked if we could do a no contest plea. I don't believe she objects. I did provide the court, I believe, with a copy of the police report and the lab test results as a basis for the no contest plea.
And I would not object to the no contest plea, Your Honor.
Do you have that documentation, Ms. Koch?
I thought he sent it to the court. I can have my staff print it out and bring it to the court.
Mr. Hunt, I'm sure you sent it in. It just didn't make it to me. I don't have it here with me. So
sure.
I'm gonna ask the prosecutor to get that. So I'm gonna put you guys on hold for just a minute, and we'll I'll bring you back into the courtroom as soon as we're ready.
Okay, thank you.
Okay. Mr. Thompson,
Mr. Vernon and I are here on Mr. and Mrs. Leland, we're both Josh Lodge, jail, docket.
Okay.
15, I believe. But that's the case I'm here on, Mr. Vernon as well.
we have cases.
Oh, I'm sorry, I'm also here on Mr. Ackerman, I haven't seen him, I can go check the lobby.
Okay, yeah, if you can just check.
Okay, I'll check the lobby for Mr. Ackerman.
Okay.
That was a plea offer made in 2023. Is that offer still good?
Yes, I think you want to discuss that. It was offers delivered in meth, have 2 dismissed felony firearm, felony possession, have the report, yes.
You guys want me to call
No
you at the
absconding.
same time?
And no absconding.
Right, but that's still,
Mr. Vernon, any objection to calling both cases at the same time?
I can do 2 minutes with my client.
Let's just take a break. Let's go mediate.
Thank you. Have a great.
Okay, court will enter not guilty plea on behalf of Mr. Leland in terms of circuit court arraignment. Ms. Koch, any objection to the bond continuing its current set?
No.
With regards to the status conference, we would ask the court to adjourn. I was made aware of this hearing at about 11:30 this afternoon or this morning. And I haven't had an opportunity to discuss the plea offer, which I just confirmed with Ms. Koch is 2023 plea offer, but she's agreed to extend that offer. So I would ask for some time to go over that with him.
Mr. Leland, have you had a chance to talk to Mr. Vernon about setting this out a little bit? So yes. Do you have any objections? None whatsoever. Mr. Vernon, how much time?
Next available day. Oh, I mean, I need.
Have you set this for the full day in November?
That'd be great.
Ms. Koch, any objections to that?
No.
Mr. Vernon, anything further in Mr. Leland's case? Mr. Thompson.
Thank you, Your Honor. Jason Thompson, on behalf of Kimberly Leland. We're in a little bit different procedural status because I believe our matter was already arraigned in circuit court through Judge Burmeister. We do have a plea offer. It's our intention to take back in 2024. Did reconnect with Ms. Leland today. It is my understanding she wishes to take advantage of that plea offer. That plea offer would be a guilty plea to count 1, possession of methamphetamine, dismissal of count 2, possession of cocaine, and the other terms of the plea is that 7411 is part of the plea, Your Honor. Our understanding is that Ms. Leland is eligible, and that further the prosecutor is requesting that she state on the record ownership regarding drugs that were found in the vehicle.
Ms. Koch, is that a correct statement of the plea offer?
It is a correct statement of the plea offer. I did make it almost 2 years ago. It's still the same plea offer. I just don't know if she's still eligible for 7411 because I don't know if anything has happened in the interim. But as long as she states on the record that she doesn't have any controlled substance convictions in the past 2 years, I believe she'd still be eligible.
All right, Ms. Leland, I'm gonna ask for you to come around this way up to the podium here. Yes.
No, sorry, this podium right here. Yeah.
To the record, they have removed my client.
Thank you. All right, Ms. Leland, were you able to hear everything we just said?
Yeah.
Okay. And did you want to go forward with that plea agreement today?
Yeah.
Okay. Can you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Leland, are you currently on any kind of probation or parole? No. Have you had any controlled substance related convictions in the last few years? I need you to speak up a little.
No.
bit. Okay, because we need to get your.
Sorry,
voice.
no.
That's okay. All right. And you understand that by pleading guilty to this charge, which is possession of methamphetamine, the maximum penalty you could face would be up to 10 years and or $15,000 fine.
Okay.
Okay. Did you need to talk to Mr. Thompson about that? With that in mind, what is your plea to that charge today?
Guilty.
So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify yourself at a trial if you want it. You understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this?
Yes.
Are you pleading guilty to this charge because you are actually guilty of this charge?
Yes, I am.
Okay. So this happened almost 2 years ago, back on November 21st of 2023, is that correct?
Yeah.
On that day, were you here in Crawford County?
Yeah. I'm guessing.
Okay. You're guessing it was on that day?
No, it was on that date. I remember the date, my dad's birthday, but I sweet for county because that's where I'm at again.
Okay. Were you driving through?
Yeah,
Is
we
that
were
correct?
passing through.
You were passing?
Yeah.
Do you have any reason to doubt that when you were pulled over, it was within Crawford County?
No. The pick was right there, so.
All right. And at that time, did you have some methamphetamine?
I did.
Did you know that that's what that was?
Yes, I did.
Did you have any legal right to have that?
No.
And Ms. Coker, Ms. Thompson, I know there were some additional inquiries that were part of the plea agreement. I don't know which one of you wants to ask about that.
Ms. Leland, there was several hundred grams of methamphetamine found in the vehicle. Who did that belong to?
That would be Eric.
All right, thank you. No further questions.
Mr. Thompson, any follow-up to that?
So just to be clear, Ms. Leland, the judge had asked you if you had methamphetamine, you said you did. How much did you have?
Oh, I thought I only had like a gram. They said it was 3 grams. or something.
Okay, so you believe you personally had between 1 to 3 grams?
Yeah.
Okay. I didn't have any further questions, Your Honor. I think that clarifies the matter.
All right, counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, and I just want to confirm for the record, you have no prior controlled substance convictions. Okay. And you're talking about Eric Leland.
Yes.
Okay, no further questions.
I don't have any further questions regarding the plea, Your Honor.
Okay. Are you aware of any threats, promises, or inducements?
No.
And Ms. Coker, are you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Thompson?
Yes.
Ms. Leland, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Between now and then, the probation department's going to do a pre-sentence report and interview with you. It's important that you cooperate with that interview.
Okay.
And then you'll have an opportunity to go through the report and talk to Mr. Thompson before sentencing. Okay. Ms. Koch, anything further on this matter?
No.
Yes, please, Your Honor. On behalf of my client, I would ask the court to consider lowering the bond in this matter. Reasons for this would indicate Ms. Leland has entered a plea at this point. I believe she has something like 8, 9 days credit. Looks like she was picked up to 14 of this month, so she's on approximately 6 days credit. For this stint, she had done some time when the charges were originally filed. I say that because given that she's doing a 7411, and given the lack of a prior record for her, I think this is going to score out somewhere 0 to 11. That's my best guess for scoring. So I don't know how much time she's going to end up from Your Honor. I think she may well not get very much time. She is very motivated to get home. She reports to me she has 2 dogs. There's something of a crisis situation where one of the dogs is actually been biting, and she believes it's going to have to be put down. So she's not sure if she can get another individual to go to that home. She has 2 dogs there, so she's concerned for the well-being of both of those dogs. She advises she can't afford the current bond, which I believe is $50,000. I understand that she was out on bond when she failed to appear before. She advised me that she was able to secure transportation. She admits she did not handle the situation appropriately afterwards when she didn't report to the court or turn herself in on the bench warrant, but she did ask me to make that motion, Your Honor. Thank you. Ms. Coe.
She's had quite a bit of difficulty, both appearing for court as well as having positive drug tests. The situation is, she already stated in the plea, she had a couple of grams of personal use of methamphetamine. Her criminal history is relatively small. I don't know what's happened in the last couple of years because we don't run their CCH and lien through again when they've absconded for a couple of years. She has a misdemeanor larceny, less than 200, and embezzlement, less than 200 from 2013 and 2020. There are some concerns with her appearance, given her history. I defer to the court as to what is appropriate at this point.
Yeah, so Ms. Leland, I have some concerns because you've been absconded for a while now. You're not local, so I have concerns that you would appear for a sentencing hearing and that you would.
I have a lady that I would stay with that would drag me here by my hair.
Yeah. Yeah, that doesn't give me a lot of reassurance. I don't know who that is. And I have concerns that you would comply with the pre-sentence report process. Now that there's been a plea entered, you're no longer entitled to trial release. And so for those reasons, I think it's appropriate to let the bond remain set as it is to ensure that you'll be here for sentencing so that we can proceed with your case. So the request is motion is denied, and we'll set this matter for sentencing in due course. That's all I'm saying.
So don't know where we're gonna send.
You're gonna be sentenced for about 3 weeks.
People versus Travis Ackerman, file number 245312.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Travis Ackerman. Your Honor, I did check the hallway at about 2:58 before the court called these matters. I can check again. I didn't see Mr. Ackerman at 2:58, obviously.
After he posted bond, I seen him, he came over to the office, it was a few days after his arraignment, so it was like mid-September. Gave him reporting days, he failed to report on October 1st. Failed to make contact with me, inform me of his updated address. Anytime subsequent, I have any contact with him. Request a warrant, Judge.
Okay, I'll ask that you do a probation violation bench warrant as opposed to the contempt scan bench warrant.
Will do.
I'll sign that now. We'll proceed with this case once he's arrested brought before the court. That's all I have. right, Mr. Hunt, are you still able to hear me okay?
Yes, Your Honor.
All right, we'll go back on the record then in People versus Knight, and let's see. So I do have the police report at this time. And Mr. Knight, are you able to hear me okay?
Yes, Your Honor.
Okay, did you hear what your attorney, Mr. Hunt, said about the plea agreement in this case?
Yes.
And have you had an adequate opportunity to talk to him about that plea agreement?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, please.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Knight, are you currently on any kind of probation or parole?
No, sir.
Right, you understand that by pleading guilty to operating while intoxicated as a third offense, that the maximum possible penalty you could face would be up to 5 years and or a $5,000 fine?
Yep. Yes.
And I'm sorry, I should have said by pleading no contest. You understand that by pleading no contest, that doesn't change the maximum possible penalty.
Okay.
With that in mind, then, what is your plea to that charge today?
No contest, please.
All right. Ms. Coates indicated she doesn't have an objection. I reviewed the police report. I think a lack of memory is an appropriate basis under which to accept a no contest plea in this case. So we'll go forward with it as a no contest. But I do need to go through your rights with you, Mr. Knight, make sure you understand all your rights. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court or any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sure.
You understand that you're giving up and waiving all of those rights and you won't have them anymore.
Yes.
Also, you don't have an automatic right to appeal the plea that you're entering here today. You can only do that by leave, so you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we talked about here on the record today?
No.
And is it your own free choice to enter this plea?
Yes, sure.
All right. So I'm in receipt of a Crawford County Sheriff's Department report. It's referenced as case number 241-200-1360 and a series of lab reports from the Michigan State Police. And they are all labeled with the number TX2417524. I'm going to mark all of those together as Court Exhibit 1. And Ms. Koch, have you reviewed all of those reports?
Yes.
Do you agree that the information contained within those reports would support a finding that Mr. Knight is guilty of the offense of operating while intoxicated?
Yes, and I would stipulate that he has 2 prior convictions.
Thank you. Mr. Hunt, have you had an opportunity to review those reports?
Yes, I have, Your Honor. I believe they established the offense. And also, I believe that they're correct. I've reviewed his criminal history, that there are 2 prior convictions in 2015.
Okay. Thank you. All right. The court's going to those as court exhibit one. The court is going to admit those as evidence in the file here today. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Hunt, are you?
No, Your Honor.
And Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Hunt?
Yes, Your Honor.
So, Mr. Knight, I reviewed those reports that I referenced in Court Exhibit 1. It's my finding that the information contained within those reports would support a finding that you are guilty of the offense of operating while intoxicated. As a third offense, the court finds there's a sufficient factual basis to support a finding that you have been previously convicted at least 2 times of that offense. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. That hearing will be in person here in Crawford County, so we make arrangements to be present here in court. You'll be notified of the date and time of that hearing, which will be in about 30 days. Between now and then, the probation department is going to be in touch with you to do a pre-sentence report. It's important that you follow through with that process and of your bond. Do you understand that?
Yeah.
And you need a number.
Phone number, please, Judge.
Do you have a number, Mr. Knight, for the probation department to be able to contact you at?
Yeah. It's 269-267-2206.
All right, thank you. Mr. Hunt, anything else that we need to address for the record today?
I don't believe so, Your Honor. Thank you.
Ms. Koch?
No, thank you.
All right, so Mr. Knight, it's just important that you stay in touch with Mr. Hunt. And that, again, that you follow through with that call for probation when you get that. Otherwise, both sides are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes our afternoon docket. All right, we're back on the record. Mr. Hassel, can you hear me?
Yes, Your Honor.
Okay, all right, we're back on the record in Hassel versus Bergman. This is file number 1716873. Having had a chance to go through the file following our previous record earlier this afternoon, Ms. Kraus, there's something that I noticed that I didn't discuss fully, and I'd like to get your recitation on it. So at the time of the show cause that Mr. Hassel failed to appear for on November 4th of 2024, can you tell me, and I know that you calculated since then, but can you tell me the circumstances that led to the filing of that show cause at that time? And if you need a minute to do that, I realize I'm asking you to do this on the fly.
Well, it's a backstory of it. So initially, the November 4th hearing was backed from an adjourn to an adjourn, from an adjourn back all the way back to July 1st. From a previous bench warrant where bond was reduced to $500 and then he was able to be released. So I could touch base on each of those if that's helpful.
Yes, yep, that's exactly.
Okay, so yes. So bear with me while I get into context of where that information is. So on July 1st of 2024, there was an arraignment hearing. The plaintiff was to appear again on August 5th of 24 for contempt hearing. And the cash performance bond was reduced to $500 and then he may be released. at the August 5th hearing, it was then adjourned as the plaintiff filed a support motion to be heard in front of the referee on August 28th. And then the plaintiff was to comply and submit job searches and anything else that was requested by the friend of the court. On August 28th, in front of the referee, the plaintiff's motion was called regarding support. That hearing was dismissed due to the non-appearance of both parties. So the uniform support order that was dated from November of 2023 is still the current order. And then the hearing in front of Your Honor on September 3rd was adjourned to October 7th. He was to continue to submit job searches, and the court would address other options for moving forward if the plaintiff has not obtained employment by that next hearing. And then the October 7th hearing was adjourned in advance due to a scheduling conflict with the plaintiff, and that all other prior support enforcement provisions remained. At that November 4th hearing is where the plaintiff failed to appear. He had not remained in contact with our office. The bench warrant had issued. Then an ex parte was submitted to the court in regards to the communication that was signed on January 15th. So the employer that income withholding was being collected from was not reported by the plaintiff, and that was discussed at a prior call leading up to the non-communication ex parte that was filed.
Okay, and then subsequent to the November show cause hearing and bench warrant, there were some payments made, as you had previously indicated earlier today on the record.
They didn't, sorry.
No, go ahead. Correct me if I'm wrong.
The payments didn't start until December of 24, so there had been no payments received in November.
Okay. And then following that, there were a number of payments made, but not up to the full monthly obligation.
2 months were December of 24, the amount of $1,133.90 was received by an income withholding. And then January of 25, $895.34 was received. And his current obligation is $883.
Okay. All right. And then the remainder of payments that were received in 25 were either partial or involuntary payments.
Correct.
What was the nature of the involuntary payments?
From some sort of tax being withheld.
Okay.
And then,
No, go ahead.
And then in regards to Michigan quarterly wages for 2025, it was reported that an income of $30,466.27 was received by the plaintiff for 2024.
All right. So, Mr. Hassel, I guess my question is this. I mean, your statements earlier were that you weren't able to see your children. I mean, what is your basis for not paying child support in this case? Why have you not been paying?
Sorry, I didn't mean to cut you off, Your Honor.
Go ahead.
Well, I'm not making up an excuse, but I came to court and you guys put an order in effect 2 years ago, and that order has not been followed one single time. Miss Bergman seems to think that because you threw all of her parenting time violations out, that she is now invincible and she doesn't have to whatever. And I tried to let you guys know that my sister, who's the supervisor for years, and legally you guys are supposed to offer me a reunification plan with my kids. In 5 years, you have never told me what I have done or why I can't see my kids. I don't even have a felony. I have one misdemeanor in my entire life, and I'm 33 years old. But right now, Josh Graham, who's a drug addict with 50 felonies, is allowed to be around my kid every single day. He hangs out with my kids. My kids are telling me he has guns and he's a felon. The last time I seen my son, he told me that Josh has guns and he rides on motorcycles and everything else. He just got out of prison a year ago. How does he have guns? And why is my 9-year-old son telling me these things? And I know I'm getting off topic and I'm not, but Your Honor, I lost my job and my boss is here to bat this war that I had to let go. And then when I got let go, I tried to collect unemployment like I was instructed to do by my boss because I was working I was making good money. You guys were taking he's here to witness. B&B Construction out of Gaylord was my boss. And for months you guys were garnishing my checks. To the point where I was making $100 a week. And I was supposed to live on that and still try to be a dad and still be part of my kids' lives and do due diligent things to be part of my children's lives. And at this point, I feel that I'm being done very dirty because I've made an honest effort. If you sit back and look at all the money that I've been forced to do, and then immediately after me missing this court date, if I purposely missed this court date, I wouldn't have called you guys on a recorded line the next day instructing that I made an honest mistake and I honestly missed the court. It was not intentional. I just got out of jail. Why would I want to come to jail again? It was not intentional. And I immediately got a job. I called and I let you guys know. And I said, I have the recorded phone call with the lady that I spoke to right after, before this court date or whatever. And I instructed to the lady, I said, I got a new job. And I said, I'm calling to let you guys know that I made an honest mistake and that I want to do this so that it doesn't affect me and my family. And all they did was tell me, well, if you give us $3,000, then maybe we'll drop the warrant. Well, court wasn't for failure to pay. My court date that I missed was because it was for us to discuss my job and everything. I was instructed to let you know at that court date about my new job, which I had every intention of doing. But my boss I was working 60 hours a week and getting $400 a month to live on. And that's not fair. And he agreed. And he said that it was best that we part ways because your guys' local officers were coming to his jobs. However they were looking, they were harassing him, walking into his clients' houses, trying to serve me papers and everything. And I mean, I'm a good person, whether you guys believe it or not. I've spent 33 years of my life staying out of trouble. And just because somebody has made a ridiculous list of accusations on me does not mean that I am who they say. I'm dealing with a very bitter mother of my children. And you guys don't have to believe me, but Ms. Bergman does not make any effort for me to be part of my kid's life. She ignores my phone calls 24/7. She answers when it's her discretion. She doesn't feel that she has to follow any kind of order, and she hasn't had a consequence one single time. She had 37 violations in a row, and you guys signed the papers and agreed that she was guilty, and then turned around and threw them all out. So now she thinks that because she got away with all that stuff, that she just is free and she doesn't have to do anything that the order says. I literally don't even, my daughter's birthday is on the 13th of this month, and my birthday's on the 25th. And my kids beg to see me. They ask me why I can't see them, and all I can say is, I don't know. I don't have a supervisor. I'm sorry. And legally, you guys should have told me what I have to do to see my kids again. Not one time has anybody told me a reunification plan to be part of my children's lives. In 5 years, I've been kept out of my children's lives and alienated. And I love my kids with everything that I am, whether you guys believe it or not. I spend every single day wishing and begging to see them. And I got to see them for 30 hours last year. 30 hours an entire year. I can't keep a job because you guys garnish it to the point where I have a $100 paycheck. And who drives an hour in every direction to go to work in a truck to live on $100? How can I? And then not only did you guys cost me this job, a year prior before me going to jail, a year prior, you guys cost me my job at Cooper Standard. I had an amazing job. You guys were garnishing my check for over 4 months, taking every single penny and leaving me a couple $100. And I keep trying to tell you guys that you're taking too much money and I can't afford that. And I don't know where you guys think that I'm rich, but I live in a little tiny trailer. I'm broke as a joke because of these situations. I've hired 2 lawyers. I've dropped over $7,000 or $8,000 to defend myself. And I have every right to try to, and if I didn't love or care about my kids, I wouldn't be here fighting and trying to be part of their lives. And I'm not asking you to hear my sob story, but what's being done to me right now is very, very evil. And my kids tell me that every day, imagine your kid calling you and saying, Dad, when can we see you? And all I can say is, I don't know. I'm sorry. I don't know. I don't have a supervisor. My sister has a job, and me and my kid's mom, we parted ways because of this corruption, all the stuff that I'm going. And I see my other son on a regular. How is it that I can see my son My other son with the other mom who says I'm an amazing father, but this mother says I'm a horrible father, and I take my 2-year-old every single week for 5 days at a time, off and on. How am I fit for one child but not my other two? Not one time have you guys told me what I have to do to be part of my kids' lives again. Not one time. And that's all I want. I want to know what I have to do to be a dad again. That's it. I just want to be a dad. I want to take my son fishing. I want to take him hunting. And I want to do things that I deserve and that they deserve as me being their father. And I've done everything you guys have asked me since day one. And I still keep getting rammed. And all I want to do is be heard. I want to be heard that my kids are screaming out to be part of my life. And Michaela can get with random dudes, whoever she wants. I have no criminal history. And the guy that she's with now is freaking older than I am, 6 or 7 years older than me. And he has 40 felonies. And I'm supposed to just be okay that he's around my kids? He's not even supposed to be around his kid, and he's using my kid's mom to be part of his kid's life, so the courts don't know that he's around his children. He has violent crimes. He has credit card fraud, drugs and distribution on methamphetamines, and he's around my kids every single day, sleeping in the same house with my son and my daughter, and I can't be around my kids. And the only misdemeanor I have is almost 10 years ago for drinking and driving. That's the only thing I've ever been in trouble for in my entire life. And I'm 33 years old, and I have to beg to be part of my children's lives. I can't keep a job because I get fired because you guys are taking so much. They're like, nobody can live on this. And my last boss fired me because he seen what was being done to me. And he said that it wasn't fair that I had to come to work for $100 a week and bust my butt in the freezing cold. And then so they let me go so I could claim unemployment. And as soon as I get unemployment, and I get on it, you guys raise the amount that you're taking and start taking every dollar of the unemployment for 2 weeks and give me $100 to live on. All because I lost my job due to the circumstances of the stuff going on. I'm trying to be a dad, but I am only human. And I won't keep rambling because I've already said what I said, but what's being done to me is wrong. I love my children with everything that I am. I've spent my entire life to try to build a good life for them. And right now I'm being kicked down every chance that I try to get up.
All right, so you're raising a lot of issues. Number one, what you got to understand is the issues regarding custody are completely different and separate from the issues regarding support.
I understand that.
We have had many different hearings regarding custody. You had a hearing in front of me. I issued a written opinion that was very detailed, explained all my rationale for that. That was in writing. You may not have agreed with it, but it is what it is. And to the extent that you disagree with that ruling or the current custody situation, then you've got to file motions. I know you filed a motion last September. I went through the court file and saw that. And that had a hearing before the referee in October. And so
I was instructed by the federal government to cancel it. They wanted to see how you were going to rule on the order.
I have no idea about the federal.
Well, I know that if you guys call the FBI and ask them if you're under investigation, they will tell you that you are under investigation. I'm being honest with you. I canceled that date because I was instructed by the federal government.
I don't care about the FBI or anything else. Anybody can investigate me that wants to. Everything I do is here in public on the record. So if the FBI wants to investigate me, that's fine. I have no idea about that. And I have no idea why anyone would tell you not to go forward with the custody hearing. So the fact is that whether you agree with the court's prior rulings or not on custody, you have every right to file motions and to have hearings, and you've always had the ability to do that, and you have done that. And to the extent you haven't followed through on it, or if you disagreed with it, appealed it, then that's on you. But to argue that somehow the court's making all these decisions without any input from you, or you haven't had any rights in this, is just absolutely wrong, and it's incorrect. You had every opportunity to do that. And custody is a completely separate thing. And because the custody rulings haven't gone your way, doesn't give you the right to say, well, I'm just not going to pay support.
That's not what
I
I
don't
said.
think that Miss Bergman's been found guilty of 37 different parenting time violations and nothing's been done to her.
I promise you,
But none of that gives you the ability to say, well, I'm just gonna not pay any support to my children. The law doesn't give you the ability to do that. You can't just unilaterally decide what you're going to follow and what you're not going to follow. And based on everything that you're telling me here today, you could have been making some payments towards support over the past year. Since November of 24, you made some payments. The law only allows the friend of the court to take certain amounts as part of wage assignments. And so it's not like the friend of the court can just decide we're going to take all of your money. They can only take up to a certain amount, and that's all based on statute. It's all based on calculations and your reported income. So if more money's being taken out than should be, then it's up to you to come to the friend of the court and say, I'm not making that much money, to report your income, to engage in communication. And that leads to another problem, which is your communications with the friend of the court are much like they are today, where you want to go into issues that aren't relevant to what the problem is. And you want to, air all your grievances about the system. You don't want to listen to what people are telling you. You don't want to do what they're saying you need to do to help yourself. You want to do what you want to do. And what results from that is these just really difficult conversations with you and harassment basically from you towards staff, where they get to the point where they have to go to one of us judges and say, we can't deal with Mr. Hassel anymore. He won't deal with us on a reasonable, rational level where we can sit down and explain to him, and he's not listening to us. And I've had you in court before. I've watched you testify. I know that's the way you are. And so when you behave that way, it puts everybody else in a position where we've got to put up rules about how you can communicate, because it ends up devolving into something that's not productive to you or to the friend of the court, and certainly not helpful to your case. And so you add that in, and that complicates everything else about how we can deal with this. So, and the fact is, Ms. Kraus, how much are the arrears? 33,000?
$33,302.56.
Yeah, so it's not like this is a new recent problem. You have not. I mean, $33,000 in arrears.
Your Honor, when I got arrested, they told me my arrearages were $21,000 just now on a body cam. The officer said my arrearages were $21,000 and my amount to get out was $5,900. So how is it that you guys have two different numbers? The police officer on a body cam told me exactly multiple times. He said you're $21,000 in arrearages on the reason you're being arrested. I know everything, and I tell you right now, I have.
Police officer doesn't work for the court, and the police officer isn't in the front of the court and doesn't have access to those records.
He called you guys.
I have no idea what a police officer might or might not tell you. What I can tell you is Ms. Kraus has the records in front of her. And so for you to say that you've done everything that you were supposed to do all the time is just not correct either, because you're $33,000 in arrears of
3 years
child support that you should have been paying to help your children that you didn't. So
when do I get to see my kids though? You guys are alienating me from my kid's life, whether you believe it or not.
You've had custody. You've had custody hearings, and I've made written opinions that explain the rationale to you. So you don't have to ask that question. You can go back and read my opinion.
One time, Your Honor, gave me a reunification plan. The federal government pointed out that not one time in this entire case have I ever been offered a reunification plan. I didn't even
file an appeal. File a motion, file something saying that we haven't done it correct. No, you haven't.
Filed multiple, and you guys always rule against me because it's all about money. That's all you guys care about is money. That's it. You don't care.
I'm not gonna argue with you, but the point is why we're here today
money.
Is again, your
all
failure
that you guys
to pay.
care about, and right now it's illegal. I'm telling you that I know you guys are stepping on your own state laws. And I know that you're violating federal laws. I can tell you right now.
Then I invite you to start filing some paperwork with that regard instead of just telling me about it on the
I
record
already
here.
have. I've been instructed to let them finish up what they have to do. I can tell you, you guys can call and ask if you're being investigated. You are 100% being investigated.
I don't care. If I'm being investigated, they'll come to me and let me know about it, and
They
nobody
will.
has. So
They know that
frankly, I
everything's
don't
done with me and my
believe you.
children. You don't believe me because I didn't take it to the state, but actually I did take it to the state, and they sent it to the federal government because they realized you think that.
All right.
I know why you think. It's because you haven't seen a state case of the attorney general, but we were informed that the attorney general is crooked, and I know that you used to work for the attorney general in Lansing, which is a conflict of interest, and they're aware of all of the things that you used to be before you're in this position, which means that they cover and they protect you. You think you're immune, and you're not.
I don't think I'm an immune, and I invite any investigation into me or anything I've ever done. I absolutely invite that because it's
I know
all in the
that
open.
you haven't been here since day one, but you have had every chance to do right by me and my children, and you've chose not to.
Okay, so again, why we're here today, you indicated earlier, you're aware that there's this support order that requires you to pay support, right?
Well, I don't agree with the order because you guys created it, and nowhere can you
I'm
talk.
not asking you whether you agree with it. I'm asking you whether you're aware of it.
I am not aware of the order up to date. No, I don't know what the current order is. Because I was silenced. I tried to call and address the issue, and you guys told me, don't call or talk again. So I did what I was instructed. I went to the next level. With the only thing you can do when you're silenced is go to the people above you. And now
You're aware that you're required to pay support under an order. Is that correct?
If you're saying that, I don't have to agree. My lawyer will handle those issues.
Okay. And you have failed to pay support over the period of time that you've been required to pay. Is that correct?
No, that's not correct. I actually had lots of money taken from my paychecks, and I have every pay stub to prove every dollar you guys took from me this year. And I also have every paper.
You haven't paid the amount as ordered. Is that correct?
Extortion is extortion, Your Honor.
Okay. I'll take that as a yes. You haven't paid as ordered.
Yes. I am not saying that I agree with it. Not at all.
Okay.
My lawyer will, I'm not answering anything that you're trying to trick me into. My lawyer instructed me to stay.
I'm not trying to trick you into anything. I'm just asking you what you have or haven't done. That's all. That should be easy.
I have made money on the record. I have had multiple paychecks garnished. They've garnished my my 401k. They garnished my paycheck for over 3 months this year. Or last year. We're in a new year now, but last year I had probably over $4,000 or $5,000 taken from me. And what's ironic is my baby mama has 3 baby daddies, and they're all in your guys' county. And we've sat paper by paper, and we can't figure out how I pay $890, and her other baby daddy who never sees his kid pays $50, and I take care of my kid 3 weeks out of the month. And then her other baby daddy only has to pay $125 a week. We're blown away. She can't even figure it out. She tried to tell you, why is it that one baby daddy pays $8? Because your guys' formulas are made up. Michaela made you think, and her lawyer, that I'm rich. And I'm actually poverty. I'm very poor. I was on assistance the entire time. Food stamps and Medicaid the entire time you guys have been pulling what you're doing. Up until a few months ago.
Based on your statements here today, and this is an expansion of our earlier record, the court finds that you were aware that you were required to pay child support as ordered, that you failed to make payments out of available resources. As you indicated, you have been working during this period of time.
I have not been working.
I further find that based on your statements that, again, that you're aware of the obligation, but because you felt that due to the court's adverse rulings as to custody and your perceived violations of orders by Ms. Bergman, that you didn't have to make those payments, or that
I never said I didn't have to make them. I don't have the money to pay. I lost money. I never said I don't think that I don't have to pay to take care of my
based on this,
do not put that in my mouth. I never said that I don't think I have to take care of my children. I had my children for 50-50 for their entire childhood. If I didn't care about them, I wouldn't have raised them for 5 years.
So are you saying that you were aware that you had the child support obligation as ordered by the court?
Yes, but I am letting you know that I cannot afford to pay it. I tried to tell you guys that I'm not making that kind of money. My paychecks show that you're leaving me $100 a week to live with. That's illegal.
Okay. All right, so Mr. Hassel, have you ever filed since November of 2024? Have you filed anything to have your child support modified?
I tried to contact you guys and all that they
It's
ever
a simple
tell me.
yes or no question. Have you done
Yes, I
that?
have filed motions. And as a matter of fact, I
Mr.
filed a
Kraus,
motion.
is there anything in the record indicating that Mr. Hassel has filed any motion since this bench warrant was issued to modify his child support?
Outside of the one that was previously indicated from August.
Correct.
August 28th in front of the referee, that's the only information I have.
Okay. All right, so the court finds that either Mr. Hassel, you failed to pay out of available resources or you failed to exercise due diligence. And so again, on this expanded record, the court continues to find that you are in contempt for failing to pay. So the court will continue its previous order. And so Ms. Kraus, if you could forward that to me. Mr. Hassel, is there anything further you wanted to say for the record today?
I'm just curious what the whole point of this court date was, to torment me mentally or what?
No, the whole purpose is to try and get you to pay the child support that you're required to pay.
Well, I don't have $8,000, and that's funny that my paper bond that the officer showed me said my bond was $5,900, which is a prime example of how your guys' county handles business.
Well, it was back in November when that
No,
was
that's
issued.
today when I got arrested.
Yeah, that was the amount that was the amount as of November 2024. A lot of time's gone by and you continue to accrue child support payments since then that haven't been paid. So of course the amount's going to be higher now than it was in November.
The amount changed $12,000 since this morning.
The amount changed from what it was in November to what it is now in November of 24. Yeah.
When do me and my kids matter to you, Your Honor? Can you tell me one
They
time
matter
you put me in
all
my
the time. They matter all the time. All you need to do is file a motion, as you have done in the past. You're fully aware of the process. So,
and it's all part of your guys' silver bullet game.
okay. All right. Thank you. That's all for this hearing today.
Well, that's it for today, ladies and gentlemen. I'm glad you all came, whoever come, and you guys are watching. Thank you very, very much. If you're not a subscriber to this channel and you like this content, please do me a big favor and subscribe to this channel and help this channel grow. Let's show the haters out there that we can do something without having to attack and take advantage of people. So that's going to be it for today. You all have a wonderful evening. Ta-ta and ciao ciao. I will see you guys tomorrow. Thank you for watching.
You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.